So Eli, is that working?
Yep, we can see your presentation and the floor is yours.
Perfect. Thank you very much. Okay, so interesting stuff, Jim. We've applied for a few of those things, so we'll see how they work. So far, they've been pretty quick, but we haven't gotten a lot of funds. So, as Eli mentioned, I am a civil lawyer in Vancouver. The stuff we're going to talk about is BC generally, British Columbia. There'll be some stuff about Canada, but it's not going to be specific legal advice. It's general concepts, kind of things that will help employers get a sense of some foundational ideas so they can make better decisions. This is about best practices. I would suggest you make best practices with more information. The more information you have, the better decisions you can make as an employer. It's not really going to be too much about union environments. Those are very specific. We can answer some questions about them. And truly, it's not going to be about federal as well. Federal works in something in Canada is a little different. That's the employees that work in banks and things like that. They have different legislation. So we're going to talk about the bulk of employees and employers and how they're affected by this COVID-19 in BC. So some of it I think you could take, it's kind of like what Jim was going through. That's for Canada. But I think a lot of things are quite consistent. So how we're going to do it is we have two sections really, and I'll go through those in a second. You can ask questions at the end of those. We'll have a couple questions at the end of each section, and then we'll have some questions at the end if there's more. This is just too big of a thing to deal with completely in one sitting. So really we're going to talk about kind of how to deal with these short-term issues, what to do right now. And then next Friday, we're also going to talk about kind of how to bring people back. Or if you're not bringing people back, what does that look like? And what does that look like with employees? And also what's an employer's responsibility? Things like safe workplace and things like that. So we'll talk a bit more about that next Friday. If there's some questions that are consistent or we think are pretty good questions, we'll try and either respond by email, later date, or we'll try and attach them to this presentation, YouTube, or Eli's going to do a blog as well. So we'll try and get those responses to you. So let me just, okay, good. Okay, so here's the two topics we're going to talk about. Is basically modification of employment duties. So over COVID-19, what happens and what do you do about it as an employer? And then termination or layoffs. I think those are very important things you want to know about before you make decisions. Things are we're starting to understand, it's been a month plus and we have a sense of how it's affected our businesses. The government's starting to talk about, maybe bringing people back, but that's going to be in a very light way, I think. And also there's talk that this could go on for a while. So if you're a trickle-down business, you might not be open 100% in a couple of weeks. You might not be open at all in a couple of weeks. And so you have to make some decisions, and those might be decreasing or modifying the employment duties of your employees, or whether you have to let them go either permanently or temporarily. So that's kind of what we're going to talk about. Just so you know, basically employment law, it's a contract. So it's a contract between the employer and the employee. It's a unique contract and it's a special contract, but that's the fundamentals of it. You can have an oral contract. So if someone just starts working, I don't know if you have employees that have just started working, they have no written employment contract, they have a contract. The courts will imply certain terms in that contract. And we're going to talk a bit about that. Big no employer should do that, but we'll go through parts of it. Another thing that people and a lot of employers I deal with employers and employees. So employers come to me when they're, have problems with employees, and employees come to me usually after they've been let go or they're having problems at work. I deal with both of those. So I have some understanding of what the questions are and what the concerns are on both sides. But let me just say, fundamentally, employment is not a right. You don't have a right to be employed. As an employer, you don't have a duty to employ somebody. And I think sometimes people come to me with that misunderstanding. You have a right to not be discriminated against, fired because of improper things, marital status, your racial status, your age, your sex, things like that. You have a right to not be discriminated against, to be fired because you're married, or be fired because you're a certain age, or because you have certain sexual orientation, but you don't have a right to a job. And so I think that that should inform employees and employers. And we'll talk about what you do with right to legally in a contract. Basically, I want to give the people watching, just like I said, information so they can make better decisions and nothing really surprises them later on. And information that employees should have too, or employers should work with employees before decisions are made. And again, best practices come from knowing your options and your rights. Okay, so the first big one is, what if I modify, decrease hours, wage, what happens? Well, employment's a contract, and the courts have said if you modify the contract in a fundamental way, you're effectively ending it. So what does that mean? Well, that means you're terminating the agreement. It means you've changed it. And so can you decrease someone's hours as an employee? Well, what you're doing is you're starting another employment agreement. You're ending that one. So you hired someone in, I'm going to pay you $18 an hour, and you say, okay, COVID-19 is coming. I just can't afford to pay you that. I'll pay you $15. That's a fundamental change, and that's what's called constructive dismissal. Now, you can do things like that, but if you do it unilaterally, you just tell your employee, hey, guess what, tomorrow you're making $15 an hour. That's constructive dismissal. And that triggers severance, termination. We'll talk a bit about that, but you should know that before you make those decisions. What about decreasing hours? So you hire someone full-time. I can't afford to pay you. I'm gonna have to pay you part-time. The courts have said that is fundamental to their job. And that does make sense, right? You were hired someone full-time at $18 an hour, and you tell them it's 20 hours a week now, and you're gonna be making 15. That's not the job they applied for, and you agreed to hire them for. That's a different job. There's some rights to that as well, but that's a different job. You've effectively terminated from the job you've hired them in. You have to know that and agree and deal with that. Now, there's the reason I talk about common law, so I'll talk a bit about that. Basically, common law is judge-created law. There's multiple levels. Every court in North America, well, actually, that's not true. Mexico has civil law, but Jim was talking a bit about civil law. Common law is in Canada, and it's in the United States. There's common law and there's legislation. We'll talk a bit about both those things, how they affect you as an employer. What about things like you tell someone they have to work at home for 2 weeks? And we had that situation here. We had someone come just from the start that came back from Hawaii, and the government said we had to quarantine them. They couldn't come into work. And we didn't really know what was going on and why too much, but we followed that advice and they stayed home and we paid them. You know, they did some work from home. They answered our phones. We were able to do that. They answered emails. They were able to do some things online. You know, this is really, Carly, generated all of us figuring out ways to do things online, you know, this being a great example. Well, there's lots of different things as well. We had Zoom meetings, and so we were able to work around that at least for a few weeks. And then after that few weeks, they came back. I would say that's not, normally that would be a modification of duties saying, hey, guess what? You don't work at the office anymore. That would be a modification potentially worth creating constructive dismissal. Again, these are the type of things you probably need to see a lawyer, you're a professional. The lawyer you deal with, hire a new lawyer. It's not something you want to Google. It's too fact specific. But the truth of the matter is that if you fire somebody, they get severance, and we'll talk a bit more about that. But there's also things called mitigating damages, and we'll talk a bit about that. But the bottom line is the courts look at what did they suffer? What kind of damage did they suffer for you firing them? Well, if in our case, we said, hey, we're going to pay you from working at home. She didn't suffer any damages. She had no losses. She got paid her same wage. So it really was not constructive dismissal. We knew it was temporary. The key is, this is a key I'm going to repeat a few times, the employee agreed to it. Okay, and the modification was so little. She did the same job she did in the office. She did it in the same way. She did the same time frame, in fact, less, and she got paid the same money, that there wasn't really much fundamental changes. But if there are fundamental changes, you should really think about an agreement with you and the employee to outline in writing what those changes are. So that's a best practice, okay? If you're gonna make a change, you have to decrease something. Probably shouldn't be fundamental at this point, and I'll tell you why when we go through the legislation. But if you make a change that's even, you don't think it's a big deal, it's a great idea to just get the employees understanding, work with them and say, hey, how about we just go through, this is how we see this while this is going on, these are the changes. The employee agrees or says they have some issues, you fix those, hopefully you come to understanding, you put that in writing, it can be as simple as an email, and then you move on. Very important, and I'll go through a couple of reasons why, but obviously, and you'll see in a couple of different things we say is be upfront, deal with the difficult things at the right time, don't deal with it at the end or when things have kind of changed or when you're trying to get back together, because what happens is, and I've seen this many times between parties in many different situations, there was a misunderstanding. I thought X, you thought Y, we're now bringing you back, these are the terms. Guess what? Oh, we weren't going to pay you, or you weren't going to accrue your vacation time while you were gone, when you weren't doing here. And the employee's like, well, you never told me that. I might not have agreed to that. Well, arguably, you probably can't do that. In fact, you can't, because the legislation says that. But that's an example of something. Deal with the issues. That's best practices. Deal with the issues before they become issues. So try and think of those things and get it in writing. Another thing that's going to be something we'll deal with next week is privacy issues. And I bring this up just because if you're asking people to stay home, if you're asking people to modify their work, if you're asking people to come into work, there's privacy issues about people that might be infected, people that might be at risk taking transit. There might be issues about people that work in a big household with people in risky industries, like in restaurants or healthcare. And the question is, what rights do the employees have to know that, and what rights do the people have to have that protected? I'm not going to get into that today, but it's one of those issues about we'll talk about next week. So a quick tip is put new terms in writing, okay? Very important. Might be a little bit of a pain at first, but please do it. It's important. It'll save you hassle later. It clarifies things that might not be clear. Please do that. If you agree it won't be a permanent layoff, what are the terms of that permanent layoff? Do you know how long? You probably don't know how long. So you should put in, this is what we're going to use for criteria to hire you back. You might have to alter that. The government may force you to alter it. That's fine. Just be upfront, deal with things before they become issues. The terms of the return. Is it going to be full-time? Is it going to be part-time? Are we going to assess it before we bring you back? Again, are you getting benefits while you're gone? Are you getting paid full salary while you're gone? You have to assess those things, be proactive, and discuss them. If you don't do that, you may be constructively dismissing somebody. Now, we talked about some of the things about constructive dismissal. Because it's an employment agreement, if you change something fundamental, as long as it doesn't fall below the standard of legislation, we'll talk a bit about that, you can kind of say, can we agree for this new agreement, employment agreement, contract, while this is going on? If the employee says yes, they've had time to think about it, it was reasonable, that's kind of the end of it. But if the employee says, you just impose it on them, you might have some problems. And it's not going to be right away. It's going to be when you're bringing them back or when they talk to their friends, and the friends are just like, oh, wow, we didn't believe that happened. So it's really good to go through the difficult questions, put it in writing, and then you'll save yourself some hassle. So that's quick tip number one. Now, I have paused here for questions. Eli, do we have any questions, or can we?
Yeah, I do see one here. Just asking if this recording is going to be available at a later date. So I'll just answer it to everybody. Yes, it will be. It will be on YouTube, and we'll also be writing a summary on Fernandez Young's blog as well. And I do see another question here for Jim, but we'll hold those questions until the end of Dean's session.
Okay.
Yeah.
Now, let me just go on to the next one, and I'm going to give you a better sense of employment law as well. So just so you know, there's no, up until recently, because the provincial government created a COVID-19 amendment to the Employment Standards Act, but up until that, there was no mechanism to lay someone off. if, unless it said in the employment agreement that they're a seasonal employee, unless it said in the employment agreement, we can temporarily lay you off. There was no mechanism to do that. So laying someone off temporarily up until this new legislation was firing them, and that got legislation, or sorry, severance was engaged. That means you had to pay them severance. So we'll talk about the new legislation in a second. Just want to talk a bit about the common law and legislation. So Employment Standards Act is the minimum in this province, and every province has one, and they're very similar. And most jurisdictions in the US have them as well. But in fact, I know this one in BC and Ontario are almost exactly the same. It's the minimum standards that you have to adhere to as an employer. It's there to ensure employers don't take advantage of employees to a minimum standard. You can't contract out of that. So there's many things that are in there. And again, there's a good reason that you get hold of a lawyer. An example is they have a severance minimum. And you can't contract out of that. If you try and contract out of it, say, you know what, we agree you're not going to have any severance when you leave. That's not valid, and it might make your whole employment contract invalid, okay? So be clear, legislation in this area might be WorkSafe. WorkSafe's another one, but Employment Standards Act is the minimum, okay? And it's there to protect employees. Then there's something called the common law. And the common law is basically judge law. That changes every time a judge makes a decision. It can change. The provincial courts here are the Provincial Court of BC is small claims court and some other courts, but it's this first court, and that's under under $50,000. I believe is the amount that it goes up to. The next court is the Supreme Court of British Columbia, and then if you don't like the decision there, you can go to the BC Court of Appeal, and the highest court in this land is the Supreme Court of Canada. And so those decisions Supreme Court of Canada decisions affect every court and every employee, I guess, for common law in Canada. We won't get too much into that, but if you do, so basically what would happen is an employee would leave, they're not happy with how you treated them when they left. There might be an argument about cause or not having cause. So I said you don't have a right to have employment. As an employer, you can terminate anybody other than for discriminatory reasons. But you have to pay them severance, okay? And severance can be determined in a couple of different ways, and we'll go through that a bit more specifically. Unless you have what's called cause. Cause means you have a reason, and that reason, and so the common law articulates the reason that you might have to have. And it's very difficult to have cause. It has to be something very serious, being caught stealing, or something quite serious that's happened repeatedly and you've warned the employee. Many employers, I just say, look, it opens you up to so much potential litigation that it might be better to pay them a reasonable amount. And so you say, look, I'm going to let them go without cause. If you lay someone off for COVID-19, you say, okay, look, we just can't afford to have you anymore. That's without cause. You've now triggered severance, and this will all become due instantly. So don't do that. You know, that's where you need to speak to a lawyer. Very serious. So if someone could go to employment standards, that would get them the minimums. That's very easy for someone to do. They can go and all they have to do is fill out a couple forms online, and now there's a complaint against an employer. It's quite easy. It's made for employees. It's quite easy for employees. It has fine base. So if turns out you didn't give someone enough severance under employment standards, you would have to pay them that severance. You probably would have to pay a fine for that severance. It's quite easy for employees to do this. They can go after directors and officers of companies. So in common law, which is much harder, costs money for employees to do, but employment standards, it's cheap. They have 6 months to do it. In common law, an employee, it can be quite expensive. They have to hire a lawyer. They have 2 years to do it. But if they get through it, unless you've really crossed your T's and dotted your I's, it's going to cost you a lot more money. So be careful. There's no such thing as temporarily laying someone off. And even in the new COVID-19 legislation, It's all legislation directed to allow the employee to leave because of COVID-19 and you can't fire them. There's no mechanism under the new legislation for COVID-19 to allow employees to terminate employers to terminate employees and not trigger severance. Okay, so let's talk about BC legislation. So this is what it's created. This is brand new and they say it's temporary, and I imagine it would be, but temporary could be years. It basically says that an employee can request unpaid leave, that means you can't terminate them, in the 5 criteria. They're diagnosed. So they've been diagnosed with COVID-19. They've been directed to quarantine. So they came back from a trip. Can't fire them. This is quite new, but this is the way it is. Employers directed them not to work because they may expose others. So you believe as an employer that that person is highly at risk. I don't know why. Hopefully follow some government criteria. And you say, don't come in. They can then say, okay, look, I'm now invoking the COVID-19 new amendments. You can't fire them. You don't have to pay them. You can't fire them. They need to stay home to look after children or dependents because of COVID-19. They work outside of BC and cannot get back, okay? So those are important things to know. And again, you don't have to pay them, but you can't fire them. So it's an unpaid leave. But if you don't follow this, the person will get their job back. Employment standards would, they just have to file a complaint. They would get their job back and most likely would get paid within that time. Quite new, hasn't been tested by the courts, not common law. Now, let me just go into the next part. Very important, you have to keep their jobs available. And you have to rehire them once COVID-19 is over. It's temporary and it's unpaid. The interesting thing is, when is COVID-19 over? And how are you going to determine that as an employer? Well, I'm also on the board of the Terminal City Club, and we've been trying to deal with this very difficult time. And the trick is, I think you have to look to government levels. You have to look to the different governments to say, look, we think this is, with this criteria, safe. And I think that, and again, we'll talk a bit more about this next week, but really, that's where you need to look for your direction. And the difficulty is we've heard on TV is, you know, there's multi-levels of government that are saying different things, and they kind of like, the federal government is all Canadians, provincial governments, all people in BC, and I'm in Vancouver, and my office is in Vancouver, and the municipal government is Vancouver, and they all kind of, thankfully right now, are somewhat consistent, but not always. In fact, every day things are changing. So I would, as an employer, best practices, I would monitor that stuff. I would take screenshots, I would cut and paste it, I would keep it, I would throw it in the file, so that you could say, if someone ever came back to you why you didn't hire someone back when you thought they think you should, you could say, this is why I didn't. But when it is time, and the government, I would suggest, is probably the one that you'll have to follow. I don't think you can make those determinations yourself, and I don't even know if you can rightfully be more cautious yourself. So when it is time, you're going to have to rehire that person, and if you don't, you're going to trigger termination and severance and have those issues. So mitigation is the example where I said that you offered someone a part-time job or a job with less money. If they don't take that job, you might be in court. If you had to go that distance, you might be able to say, hey, look, I offered them something, and the courts may take that away from them. So let's say that they won an award for $30,000, but they could have worked for $15,000. They would only get $15,000. So they have a duty to mitigate. They have to look for a job. They should accept job offers, and they should also take the government subsidies. I know Jim's gone through these on different days. They can't just sit there and collect your money. They have to make a decision. Now, this is the most important thing I'm going to talk about today, is the employment contract. So, and the difficult thing about this presentation style is I can't see your faces. So I can't see if some of you are asleep, or some of you are just not paying attention, or some of you are looking at it like, I don't know what you're talking about. I have been doing this for a while. I try and, start with good fundamentals. But if I'm not making sense, please ask me a question, or, just ask me to reiterate. But I'm going to go through a specific example about severance. So you've terminated someone either purposefully or by accident through constructive dismissal, and now you've triggered severance. We've talked about Employment Standards Act. So Employment Standards Act says that a person gets 1 week per year of service, up to 8 weeks. So you can see your exposure by law is a maximum 8 weeks. Okay. Common law says, though, a person should get severance 1 to 4 weeks per year of service, depending on 4 factors, 4 to 5 factors. So how many years with the company, how old they are, their position, and the industry. And so let's give an example. A middle manager has worked, is 50 years old, has worked for you for 15 years, and probably, and your industry is very specific. So you do CN rails, you're the one, your company builds the rail ties. Okay, so there's not going to be a million of those jobs left out there. That person is probably going to get between 3 and 4 weeks per year of service. They've been there 15 years. That's 45 weeks. That's 11 and a half months for almost a year. And so you've triggered that, maybe accidentally, maybe on purpose. And because you didn't have an employment contract, you now have to pay, you go to court, and the courts will now look at that criteria. And you could have to pay a year's worth of salary to this person. If you had an employment contract, you could have in that employment contract the terms of severance. Okay, we'll talk a bit more about that, but very important. Also, I want to note, and this happens more than it should happen, the severance awarded by the courts, which I now said in this case would be 11 and a half months, could be increased because of employer conduct. So, employer was not very sensitive. Employer was aggressive. You either might be or been experienced with, or, I run a small business. Sometimes small businesses, the people that run it get highly stressed, and sometimes they have knee-jerk reactions, and they're unprofessional and they're improper, and they yell at people, or, who knows? But they're the employer, and that's conduct, not becoming, particularly when you're firing someone. I've got some horror stories that, horrible things that people have done. The courts say that's not right. You shouldn't. This is a difficult thing for employees. This is how they make their living. This is how they survive, feed their families, pay their bills. You shouldn't admonish them, embarrass them, or make them feel bad about themselves in the process of letting them go. If you do that, that could increase what you have to pay them. Now, I don't know this is true, but arguably, if you let someone go during COVID-19 and you do it harshly or improperly or without, reason, it may increase, some damages the courts give them, or it may not. Courts might say everybody's under stress. I work with clients now through this. My office has been open. We've had skeleton crews. We've had these Zoom and phone calls. Everybody's under stress. They don't know what the courts are going to say. Nobody knows what the courts are going to say when these things start trickling into court. But just do the right thing, and you'll have less worry about that. Always get a release. So now we're going to talk about severance. In employment standards, you let somebody go, you have to give them that 8 weeks. Okay, just if you've been an employer for a while, you know this. You just have to send them that 1 week per year of service. You just send it to them. You have to send it to them almost immediately. There's no debate. There's no discussion. That's what's owed. However, the common law or the court severance we talked about, that's something that, remember I said it was 1 to 4 weeks? Well, that example I gave you could have been 4 weeks, could have been 3 weeks, could even be 2 weeks. There's lots of factors, a lot of moving parts. That's a lot of money. That goes from, 11 months to 8 months to 14 months. That's thousands of dollars. So there's ways to deal with that. Effectively, if you're a good employer, and best practices, I would say, are a good employer, and we'll talk a bit about common sense reason why. You want to give them a fair offer. I have many clients that do that. I say, look, this is what in a bad day in court they're going to get. This is what them in a bad day in court you're going to have to pay. This is what I think it's worth. This is what I think they'll probably get. Why don't you offer them that, or maybe a little less, some negotiation rooms. But you do that only with a release. It's no lawyer would ever let you, I don't think, give them that court-ordered top-up severance without a release. Because the release says, hey, this is the end of this. You agree to take this extra money, because you can't do this don't do this with employment standards. It's improper to do it. But you agree to take this extra money in exchange for a release. Okay? That release means that they can't come back later and say, wait, I thought about it. It's been 6 months. Because remember, they have 2 years to sue you. They can't come back and say, I wanted to renegotiate, or I think that was wrong. There's important parts to it, though. And so never give them this court-ordered money, this sort of court-directed severance. What the courts would maybe give you other than over employment standards without a release. But when you give it to them, you should give them that offer, give them some time to think about it. So put the offer together in the letter and invite them to go to a lawyer, because the employer-employee relationship is not one of fairness. Employers have lawyers often, employers have lawyers helping them, employers have got experience doing this, employees may have never been fired in their life. Don't give them a couple days to look at it, invite them to go to a lawyer. Unfortunately, lawyers do this as kind of our system. They might counter it a different offer. You come to an agreement, get them to sign the release, and hopefully that's the end of it. Don't ever pay severance above employment standards without a release. You can also put in other clauses, not many in the release, but you could have a confidentiality clause. We're not going to talk about this. I don't want you, like this was a difficult time for you and a difficult time for us, but let's just move on. Very important to do, okay? Quick hit tip number 2. This is the biggest tip I can give you today. Always have an employment contract. You should not have an employee that has an employment contract. So let's talk about that guy. We talked about that middle manager, 50 years old, worked for you for 15 years. You make ties for C and Rail. Now, without an employment contract, he can get 11 and a half months, probably, maybe on a bad day more. $60,000, $70,000. With an employment contract, you can say your severance is limited to what employment standards gives you. You should say it that way because employment standards might change. And if you say, I'll give you 8 weeks at a maximum, 1 week per year of service for 8 weeks, that's it, which is what employment standards says today, that's fine. But if employment standards change tomorrow, and your contract still says 8 weeks, which it probably would, because why would you change it or go back and look at it? You've now potentially voided your employment contract. So what we recommend to clients is just say, you get minimum severance required by employment standards. Save yourself $50,000 out of the gate. The other thing is we talked about changing their duties and write it out, get their expectation and talk about, it's a great time to actually go through their expectations too and your expectations. It's a little bit of work, but say you're expected to come in. You're not being a difficult employer if you have reasonable expectations. And you know what, if they think you're being a difficult employer, why not talk about it before you've hired them? If they think you're not giving them enough severance, why not talk about it before you fire them? You might want to give them a very generous severance. I think that's a great idea. It's a great motivation for them to hire, to work with you. But don't do it by accident. Do it by intention. They'll probably even say, oh, wow, that's great. But if you don't have an employment contract and you don't specify this term, this is only one of the terms that employment contract can bring to light. You're basically just giving away funds determinative on what the courts have said or will say when that person is terminated or leaves constructive dismissal. So, quick tip, the only quick tip, please, is always have an employment contract. It'll save you lots of money. It'll make for happier employees. Look, if your employee says, that's ridiculous, I don't think that's fair, then talk it out then. Don't have them work 6 months and say, oh, by the way, this is another thing you have to do. Now they're disgruntled and unhappy. And you know what? If 4 or 5 people come to you and say, I think that's an unreasonable term in your employment, and I don't want to work for you, maybe you should think about changing it. But do that rather than kind of not dealing with it. Okay? Again, employment contract, give them some time to review it. Advise them to go see a lawyer. It's not a fair relationship. You've hired multiple people. You've had to hire a lawyer to look after the contract. Give them the fair, the reasonable thing, the same thing, so that they can't say later, I was forced into sign this, I didn't even know what it said. You know, if you hire someone that doesn't speak English that well, offer to translate it. Because ultimately, that employment contract, if they sue you later when you terminate them, you could go to the court and say, hey, this is our contract. The court's going to say, my hands are tied. There's nothing I can do. But I have many employees come to me and say, hey, I've signed an employment contract. Hey, I've signed a release. And I say, okay, tell me the terms that happened. And then I tell them what their options are. If the term was, go get a lawyer, give them time to sign it, that's kind of the end of it. Any questions up to now?
If anybody has a question, please feel free to ask it.
Is there anybody out there? Eli, is it just me, you, and Jim? Okay, so Eli, how much time do I have left?
So I believe we're actually out of time at this point.
Okay.
We went a couple minutes over.
Okay, I'm ready to just give the best practices overview then. So the people that are watching this on YouTube, you missed your opportunity to ask questions. All right, so best practices. Keep employers, we've done that. The 75% thing is great. Work with employees if you have to modify a job as little as you can, but get employees' agreement in writing. If you have to let them go, do so with an agreement to bring them back under this new COVID legislation, or pay them severance in exchange for a release. Be proactive. Always have an employment contract. That's it. Thank you very much. We don't have any time for questions. That worked for me.
Fantastic. Thank you so much, Dean, for giving us your time. I know that we did go a little bit over today, but Jim, there was a question for you that was asked quite a while ago here. So I'm just going to mention it really quickly. I believe it is referring to the, can they earn up to an additional $1,000 in 2 weeks or 4 weeks? I believe that is referring to the Canada Emergency Response Benefit.
Right. The program says that you can earn up to $1,000 every 2 weeks. So that means about $500 a week, okay, without losing your benefits.
Good. Good. Thank you for that clarification. So as always, if there are any other questions or if we have a question that's more confidential, please feel free to email us. You just saw Dean's email there on the screen. Our general email address is info@fyinternational.com. And that will do it for today. As Dean mentioned, next Friday, May 8th, he will be with us again to go over part 2 of his presentation about starting to bring people back and rehiring. So we'll look forward to that. And registration for Friday, May 8th will be open on our website very shortly. So Jim, thank you so much. And Dean, a big thank you to you for giving us your time. And thank you to all of our attendees as well. And we hope to see you next time. Thank you.
Bye, Jim.
Thank you. Thank you, everyone.